Alright, the final S of spaces. Yo, YouTube. It's your boy, Lawless, back with another one. So, final S is special needs. This is really just anything that's non-crime control purpose, just to like protect general safety. You'll see like DUI checkpoints, would like fall under this. TSA kind of checkpoints falls here. ICE, I believe, also falls here. But yeah, let's get into it. Administrative needs and vehicular checkpoints. So they have like a lower threshold than I guess still like probable cause, but just at a lower standard. And really they don't require the warrant. Because again, from this perspective, it's that we're not using like these types of searches on a particular person. It's just a broad sweep of everyone really. So like a DUI checkpoint, anyone that comes through that road gets checked. Um, but yeah, it's not designed to go at a particular person. I think it was let's see, Kamara v Municipal Court. Um, so yeah, the inspector does not necessarily depend upon specific knowledge of the condition of the particular dwelling. So I think that was like health code related. But yeah, it wasn't like design specific to go at that dwelling. Um, it's just part of their normal search. So like food inspector goes around city, hits up a bunch of different restaurants. It's not particular to anyone that something's happening. It's just a part of their general safety. Let's see, two characteristics. Search's primary purpose or immediate um, objective. So, search's primary purpose or immediate objective is a special need and not merely enforcement of criminal law, but may include crime control components. Again, that's like the DUI, border checks, airport checks. I think DNA from an arrestee. Ooh. Searches are not targeted to a specific person, but broadly applies to everyone and anyone engaged in specific activity. And so, of course, we use a balancing test, the significance of that government need, the efficiency of the search, um, the intrusiveness of the search, and privacy interests of the individual being searched. Let's see. There's inventory searches, border control, searches of like prisoners and parolees. There's no expectation of privacy with that. Prisoners, parolees, probationers. So yeah, try to avoid any of those three P's being labeled that. Um, Border control, that's like a fixed location, so it's not like you're going around searching for folks. Um, well, there might be exceptions to that. Then again, I don't know enough about ICE and their raids and whatnot, or however that works. The inventory searches, kind of like when your car gets, you get arrested and you can't just like leave your car there to get it impounded. They'll do like that search to protect like your property, so you can have like a list of what you have in there. Avoid it. It helps them avoid any false claims of lost or stolen property. But then again, you don't necessarily need to be the owner. It could be a stolen vehicle, but they'll take all this inventory of just like what's with that vehicle, and helps protect the police from any potential damage. So let's see, New York v. Berger. Police may conduct administrative search of junkyard to prevent chop shops. All junkyards are subject to search. Warrant or announcement would be ineffectual, and statute allows it. That makes sense. I mean, notifying people that you're going to be searching them, it's allows them to prepare in case they do have something on them. So like the chop shop, it's like, well, let's clear out all these cars. At least in New York. Eh, probably in general, actually. You know, notice wasn't really necessary. It's an administrative search, so it's kind of odd because a lot of these searches do have a crime control component to it, even though it's for the general public, general safety. But that's kind of the way it goes. Let's see, Maryland v. King. In this case, they found that it was constitutional to take DNA of an arrestee because the statute required it of all arrestees. So it wasn't like an individualized suspicion. The court kind of, the significance of the government need. Let's see. Identifying persons necessary and how arrestee should be detained, and bail determination. The efficiency of the search in meeting that need. It was supposed to be safe and accurate way to process and identify the person, the arrestees. The intrusiveness of the search. They say that it was minimal. I mean, taking DNA, I think, is probably one of the most intrusive ways, but they say it was minimal. An arrestee has a lower expectation of privacy. Fingerprinting and photographing were used as analogies within that case. Privacy interest of the individual being searched. Well, I guess again they had a lower expectation of privacy. But here the dissent, or you might agree with the dissent here, that your DNA is very unique to you. I mean, unless you're a twin, it's pretty specific to you. You name that DNA. It's like after you, or they'll name the DNA after you. The DNA is used to find matches like unidentified DNA for unsolved crimes, whatever cold cases. So test should be for the dissent thought the test should be for those that were actually convicted and not just arrested. Because now you're holding these arrestees who could possibly be innocent people. You're subjecting them to this search. And yeah, it was intrusive in nature. But they were never found to be like guilty yet, at least. But yeah, that was the dissent's opinion about that. But they didn't win, so it is what it is. So for now, DNA DNA of arrestees, it's constitutional. Yeah. Until next time, YouTube. Peace.